there are many types of bail which are provided in Cr.P.C. The bail under section 436, 436A, 437, 437A, 438, 439, 167, 2 of Cr.P.C. ನಲ್ಲಿ there are many kinds of bail. Just we have to refresh our memories regarding these provisions, when we have to invoke, where we have to invoke these provisions of law. As we know that the bail under section 436 of Cr.P.C. has to be claimed as a right. The accused has a right to claim bail in a bailable offence. Such bail can be granted by the police officer who arrests the accused, and even the magistrate or the court has jurisdiction to grant such bail. You need not worry about whether the bail will be granted or not. It is a right of the accused to claim bail. So there is no problem in that while getting the bail. In case of bail under section 436A, we have to see which are the offences alleged against the accused. Section 436A provides that if the accused is arrested and he is detained for more than half of the punishment prescribed for a particular offence, if the offence is not punishable with death, then he has got right to get bail on executing personal bond. This will happen only when the accused is detained more than half of the punishment prescribed to the offences. Then we normally encounter the provisions of 437 and 439. 437 has to be invoked before the magistrate, and 439 has to be invoked before the Sessions Court and the Hon'ble High Court. The criteria for granting bail under section 437 and 439 are similar. However, wide discretion is given to the District Court, Sessions Judge and the Hon'ble High Court in exercising the bail under section 439 of Cr.P.C. ಇದೇ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ತಮಗೆ ಹೇಳಲಿಕ್ಕೆ ಇಚ್ಛೆ ಪಡೋದಂದ್ರೆ, while dealing with these bail applications, what the court will search for, while you were arguing the matter, the judge will see which offense the accused is charged. What are the allegations against the accused? What is the punishment prescribed for those offenses? The nature of the offense, antecedents of the accused. All these factors are to be considered by the court while dealing with the bail application. Therefore, whenever you want to argue before the court in the bail application under section 439, first you have to focus on these areas, that this is the offense, the punishment prescribed for this offense is this much, and if the accused are coming within the proviso of section 437A, that woman, sick, etc., you have to focus those facts first to the court, so that the judge, presiding officer will know, yes, what is the punishment. He will form an opinion whether the bail has to be granted or not. He will reserve the order for bail, but before reserving, he will form the opinion whether the bail can be granted or not. Then, therefore, the advocate friends must have to focus on these factors while arguing the case. Then, if the offense is very serious, you have to show that there is no prima facie case, or there is a prima facie case. What are the material placed by the prosecution to prove the allegations made against the accused? Whether there is a prima facie case or not, that will be seen for limited purpose. The court will first look into the nature of the offense, punishment prescribed, and criminal antecedents of the accused, if any. Therefore, I urge you all to focus all these points while arguing before the court under section 439 of Cr.P.C. Then 438. 438, you must understand that 438 can be invoked only in non-bailable offences. If the offences are bailable, you cannot maintain application under section 438 of Cr.P.C. Even in 438 of Cr.P.C, while arguing the case, you have to again focus on the gravity of the offence, nature of the offence, punishment prescribed for the offences, etc., even for prima facie case. There is a special provision under section 438 of Cr.P.C that even the bail can be granted even if there is no registration of FIR. You can seek the anticipatory bail even if there is no registration of FIR and if there is a threat of arrest in non-bailable offence. That has to be made out. You have to write in the bail application that even though there is no the FIR has not been registered by the police, but the petitioner apprehends under apprehension of arrest in non-bailable offence. That is sufficient to invoke section 438 of Cr.P.C. Then we have to switch on to default bail under section 167(2) of Cr.P.C. What happens? The courts will remand the accused from time to time in a crime stage, but there is a restriction that remand shall not exceed 14 days at a stretch. There is another restriction that the court shall not remand the accused for more than 60 days or 90 days. If the offence is punishable with punishment prescribed for 10 years, up to 10 years, then the court has to remand the accused up to 60 days, not beyond 60 days. Similarly, 90 days. In order to invoke the provisions of default bail, the accused who is under custody has to wait for 60 days or 90 days. After completion of 60 days or 90 days, you have to move in a bail application. If the prosecution or the investigation officers files charge sheet after moving your bail application, then there will not be any hurdle for the accused to get default bail. If the bail application is not moved or the accused is not exercised his right to get bail, default bail, before filing the charge sheet, even after 60 days or 90 days, then the accused may lose his right. Therefore, whenever case arises that the charge sheet is not filed before 60 days or 90 days, you have to move application on 61st day or 91st day. So the accused will be having right to get bail. These aspects are to be carefully taken care while you are appearing for the accused who are in judicial custody. In filing the bail petitions, what I have observed that there will be unnecessary facts or grounds taken in the bail application. Therefore, that has to be avoided. What are required under the law, that has to be contended in the bail application. Even if you go beyond the requirement, the court will, yes, it will be ignored. However, your talent will be ascertained while reading the bail petition itself. Therefore, even in filing the bail petition, you must be careful and restrict your contentions for which is required for the accused to get bail. Unnecessary things has to be avoided. This much I can say in this occasion, and if there is any query or any suggestion, it is welcome. Thank you for organizers for giving opportunity for me to deliberate